Hey guys, it's Karalynn and welcome back to the podcast. Today we're going to do another chapter in Trust Your Gut. This will be chapter 6. So Trust Your Gut is a book I wrote about residential construction contracts and all the things that need to go in it based on my 20 years of experience that you should have in your contract as a residential contract. So, I'm taking each chapter as an episode, and so you can listen to each chapter kind of like a cheap Audible, and you don't have to read the whole book. So today we're doing chapter 6, and chapter 6 is called Escape Clause. And here's the first line. Construction is just like a marriage. Wait, what? That's right. Think about it. Both start with big dreams, lots of excitement, and the promise to build something beautiful together. But just like a marriage, there are times when things don't go as planned. Maybe the homeowner turns into bridezilla, or unforeseen circumstances make you want to run for the hills. So what do? You protect yourself with a prenup, or in construction, an escape clause. An escape clause in a construction contract is like a prenup for builders. It's not about predicting disasters. It's about being smart. If things go south, this clause gives you both a way out to call it quits without dragging each other through a messy divorce. You get paid for the work you've done, the homeowner finds someone else to finish their dream house, and everyone walks away with dignity and wallets intact. In this chapter, we'll explore the essential role of the escape clause in construction contracts, your built-in safety net that allows you for a clean exit when things go awry. You'll learn how this provision protects both the contractors and homeowners from unexpected challenges, minimizes financial risk, and ensures a fair resolution if the project doesn't go as planned. What is an escape clause? An escape clause allows you to walk away from the contract without breaching it. It essentially gives you a legal exit. It allows you to cancel the contract with 48 hours notice regardless of the reason. You'll be paid for the work you've done up to that point, and you'll refund any money that you haven't spent. Here's an example of the contract language you should include in your contract. Contractor can cancel this contract for any reason or no reason at all with 48 hours notice. It's simple, right? Yes, but only if you include an escape clause in your contract. If you don't, walking away without a proper notice or reason means breaching the contract, and that opens you up to financial consequences. And I'm talking about serious numbers here. Let's say you're remodeling a kitchen, and your contract quotes $100,000 for the job. Halfway through, you and your homeowner are at each other's throats. The tension is too much, and you walk off the job. The homeowner hires somebody else to finish the work, but the new contractor charges $130,000 for the same scope of work. Guess who's liable for the extra $30,000? You are. Walking away just doesn't mean forfeiting money you're owed. It can mean paying out of pocket for someone else to finish the job. That's why an escape clause is so important. It allows you to exit the contract without being in breach, protecting you from legal and financial headaches. Why you need this clause. We've already learned that the contracts are promises, solid legal promises. You're agreeing to complete a certain scope of work for a certain amount of money. When you sign that contract, you're bound by its terms. But what happens when life throws a wrench in your plans? What if the homeowner becomes impossible to deal with? What if there's a personal emergency or supply chain issues delay your project indefinitely? Without an escape clause, none of these situations are valid reasons to cancel the contract. You're still on the hook to finish the work, even if you don't want to or can't. Reasons like toxic clients, family emergencies, illness, material shortages do not release you from your contractual obligations unless you've built in an escape clause. You're stuck no matter how justified you feel in wanting to leave. But even with the escape clause, it's important to understand how to use it properly. You can't just pick up and leave without notice. The escape clause typically requires you to give the homeowner a heads up, usually 48 hours, before terminating the contract. Once you've given notice, you're free to exit, refund any unused funds, and get paid for the work completed without worrying about legal repercussions. The escape clause is often one of the most important sections in any contract. Without it, you could be tethered to a project that's not worth your money, time, or health. So make sure it's in every contract you sign. Not having an escape clause could mean opening yourself up to damages, lawsuits, financial losses that are completely avoidable. By including this clause, you're giving yourself the flexibility to walk away from the project without breaching your agreement. And sometimes that flexibility can extend to renegotiating the terms of your contract after misquoting a project, as we'll see in Kevin's story. Underbidding a project. Kevin been in a construction business for a while. He took a project in Michigan, bidding on a job that seemed straightforward enough. Everything looked good on paper until he realized he'd severely underbid. He'd forgotten to include $20,000 worth of work in his pricing. Now, if he finished the project, he'd be paying out of his own pocket. Suddenly, the project wasn't just about getting the job done, it was about saving his business from a financial blow. The missing $20,000 wasn't just a major oversight, it was a significant chunk of the project's budget. And Kevin faced a tough decision. He could walk away and risk being sued, leaving himself on the hook for the additional costs the homeowner would incur to finish the project, or he could finish the job and absorb the $20,000 loss and move on, knowing it would be painful, but an invaluable lesson. Kevin chose the latter, deciding to eat the cost to finish the work. It was a hard pill to swallow, but it saved him from a lawsuit and more financial damage down the road. He walked away with a bruised ego and a lighter wallet, but his business survived. Now, if Kevin had included the escape clause in his contract, the story might have played out differently. Instead of eating the $20,000 loss, he could have gone back to the homeowner and said, "Look, I underbid this project. I can't finish it unless we renegotiate the terms. Here's our options. We either add this amount to the contract or I'll have to cancel." An escape clause wouldn't just let Kevin walk away. It would have opened up the door to renegotiating, giving the homeowner a choice. Either adjust the contract to include the missed clause or find somebody else to finish the project. This would have been a clean way out, legally protected, and could have even led to a fair compromise. Had Kevin used the escape clause, the homeowner might have been upset. No one likes hearing they'll have to pay more, but that's part of the negotiation. The homeowner might have explored other options, such as getting new bids to see if other contractors could finish the job for less. In many cases, however, homeowners opt to continue with the original contractor if the relationship is still intact and the price adjustment is reasonable. Kevin could have ended up with a change order in place, adding $20,000 to the contract, and continued the project without the financial hit. It would have been a far less painful way to handle the situation. Even without an escape clause, it's important to remember that you can always talk to the homeowner. You never know what they'll say. In Kevin's case, he chose to eat the cost, but the conversation might have opened up possibility of splitting it. Many homeowners appreciate the honesty, and I've often witnessed them willing to meet the contractor halfway. After all, no homeowner wants a contractor cutting corners elsewhere to make up for lost money. Kevin's situation teaches valuable lessons. Mistakes happen, and sometimes they're costly. But an escape clause in your contract will give you yourself the flexibility to renegotiate when things go sideways. You're in breach. Now what? If you decided to walk away from a job for whatever reason, what would happen? Well, the first thing to happen comes in the form of a demand letter. A demand letter is usually the first step in the legal process. It's like an official warning from an attorney saying, "Hey, you didn't follow through with the contract, and my client has been damaged as a result." This letter will outline the alleged breach, the financial damages that the homeowner claims you're responsible for. Demand could be something like, "Come back and finish the work," or "We're hiring somebody else and you'll be liable for the extra costs." In some states, especially with residential construction contractors, homeowners are required to send a demand letter before they can even think about filing a lawsuit. It's your opportunity to fix things before things escalate to court. The most important thing to do if you receive a demand letter is not ignore it. Here are the 4 steps to follow if you receive one. Step 1, don't panic. Receiving a demand letter can be intimidating, but the first thing you need to do is stay calm. As long as you respond within the given time frame, usually 30 to 60 days, you're still in control. Panicking won't help. Planning will. Step 2, gather your documents. This is where preparation is key. As soon as you receive a demand letter, you need to collect everything: contracts, change orders, email, text messages, photos, any documentation related to the project. The more you have, the better you'll be able to defend yourself. Memories fade, so it's also a good idea to create a detailed timeline of events, jotting down everything you remember about the project. This will help keeping your facts straight as the case moves forward. Step 3, call your attorney. Once you've gathered your documents and made the timeline, it is time to get your attorney involved. Show them the demand letter and all your supporting evidence. Your lawyer will usually draft a response letter, sometimes with a settlement offer or proposal to finish the work, but the goal is to resolve the issue quickly before it spirals into a full-blown lawsuit. Here's good news. In about 95% of cases, if you address the demand letter at this stage, the issue can be settled out of court. Most homeowners just want the work completed. By engaging early, you might be able to finish the job or negotiate a reasonable settlement. What happens if you ignore the demand letter? Now, what if you ignore the demand letter? This is where things can get costly fast. After 30 or 60 days of no response, the homeowner will likely file a lawsuit. When that happens, you'll not only be defending the breach of contract claim, but you also have to deal with the fact that you had to hire an attorney, and guess what? You could be responsible for their legal fees too. By the time you reach the lawsuit stage, you're already playing catch up. The chances of settling for a reasonable amount are much slimmer, and the costs skyrocket. What might have been settled for a few $1,000s in the demand letter stage could now blow into hundreds of thousands of dollars in legal fees, damages, and other penalties. Ignoring a demand letter and letting the case progress to court can be disastrous. If you go to trial and lose, you could be on the hook for the homeowner's damages, attorney's fees, and potentially your own legal cost. And if you don't include an escape clause in your contract, there's no easy way out. You're fully liable. In short, you could go from paying the smallest settlement during the demand letter phase to owing hundreds of thousands of dollars after a drawn-out lawsuit. I cannot stress this enough. Do not ignore the demand letter. A demand letter is the first domino in what could become a very expensive and time-consuming litigation process. But here's the silver lining. As long as you don't ignore it, you have options. You can settle, you can finish the work, or negotiate a deal. But the moment you ignore it, you lose control. By responding promptly and preparing a strong case with all of your documents in order, you can often resolve the issue without ever seeing the inside of a courtroom. And that's the best outcome anyone can hope for in these situations. The power of an escape clause in court. Let's say you've been smart. You include an escape clause in your contract. Now, despite that, the homeowner sues you. What happens next? Well, the escape clause might just be your saving grace. When you've got the escape clause, your chances of quickly getting out of a legal mess increase dramatically. Once the lawsuit is filed, your attorney can help you submit a motion to the court essentially saying, hey, judge, my client didn't do anything wrong here. Their contract allows them to leave the project, no questions asked. With that, you can be out of court much faster, sidestepping drawn-out legal battles. The escape clause clearly states that you have the right to cancel or walk away from the project with proper notice without breaching the contract. So when the homeowner tries to claim otherwise, the clause acts as a solid defense. In most cases, this is enough to stop the lawsuit dead in its tracks. When a homeowner's attorney receives a response letter from your side outlining that they had every legal right to leave because of the escape clause, the case often ends right there. Any competent attorney will take a look at your contract and see the escape clause and realize pursuing the lawsuit case won't go far. They'll likely advise their client to drop the lawsuit rather than waste time and money on a losing battle. Sure, there are some attorneys who might push forward, not necessarily because it's in their client's best interest, but because they're willing to bill more hours. It happens. But even in those rare cases, the escape clause remain your shield. In most instances, the case can fizzle out as soon as the clause is brought to light. Having an escape clause isn't just about avoiding lawsuits. It's about doing so quickly and efficiently. Without one, you're forced to navigate a full legal process, which can be slow, expensive, and stressful. But with an escape clause in place, you can file a motion that says, I followed the terms of the contract, I'm not in breach, and I'm out. As close to a legal parachute as you can get. Key takeaways. Leave yourself a way out with an escape clause, otherwise you could be in breach of contract. You could be liable for damages without an escape clause. The escape clause gives you an opportunity to walk away from the contract without being in breach. A clean break. Just like a prenup, an escape clause sets you up for a clean break. No drama, no lawsuits, No awkward alimony payments, just mutual agreement that says, hey, this isn't working out. An escape clause isn't just a safety net. It's a smart strategy for protecting your business when unexpected things happens, as we see with Kevin's story. Having this clause would have saved him from a costly mistake that nearly put him out of business. By providing clear path to exit a project when necessary, an escape clause minimizes financial risk, prevents legal headaches, and preserves your peace of mind. Without an escape clause, you're left vulnerable to situations that could drain your time, money, and sanity. Including this provision in every contract gives you the flexibility to handle unforeseen challenges and ensure both you and your client have a fair way out if things go south. Before signing any contract, you better include payment terms, and we'll discuss payment terms with your clients, and we'll cover that in the next chapter. Hey guys, if you like all the information that we're getting here on this podcast, I encourage you to sign up for our newsletter. It's free, full of other great construction legal made easy information, contract terms, liens, and collections. So if you'll find the link in the show notes. Thanks.